Hello everyone, my name is Venkatesh Gaikwad and I recently completed a moot court competition that was organized by Octopus Law School. Now this very specific moot court competition which attracted me is because it was for learners, for primary and secondary year law school, where you are learning what is mooting, what is research, how do you argue a certain thing, how do you research and find judgments. This competition was not a national or district or international level. This was for learners who are in their primary years learning what is mooting. So I participated in this moot court competition having no idea what to expect, but it turned out very well. So I have recorded my performance that I have given and I want to share it to you all. So but before sharing the performance, the actual performance, I would like to shortly picturize what the moot preposition is all about, because if you don't understand what this moot preposition is, you will not be able to understand or comprehend what I am trying to argue and what the judge is questioning me about. So the problem basically revolves around eco-sensitive zones and the industrial park that is constructed around it. So this is the problem. Suppose this is India and in Maharashtra a certain area is there. It is in a coastal area, that is Harinagar. Now this Harinagar is in a coastal area and the current government established a lot of schemes regarding development, sustainable development and establishing industrial parks. Now under such a scheme, this Harinagar area was set up to build an industrial park which was then will given to the companies which will produce sustainable energy resources. Now what are sustainable energy resources? That is solar energy, wind energy, atomic energy are to be set up here. Though it comes in a special economic zone where there are different laws apart from the country regarding trade and commerce. But this Harinagar was classified under CRZIA. Now what is CRZIA? Break it down, let's break it down. CRZ, that is Coastal Regulation Zone Notification 2011. Now this notification has divided eco-sensitive areas, that is where ecologically endangered species are residing, in various categories. Now IEA specifically, IEA is the very strict authority where no construction is allowed, because very endangered species are residing here, their nesting grounds are residing here. But then what happened is, before starting the project and making a joint venture, this classification was changed to CRZIIIB. Now why this classification was changed? Because this IIIB provide leniency for construction. It provides a free hand to the government to do whatever they want. Now after this reclassification, a company and central government created a joint venture with a Reliable Company Limited, Reliable Constructions Private Limited specifically. This company and central government created a joint venture for the construction of industrial park on Harinagar. So after they started, after a year, in July 2023, WWF, that is World Wildlife Federation, they appointed a committee and sent them to this state to examine Harinagar. Now what they examined is, there is a certain species of turtle that is residing there, that is olive ridley turtles. Now what happened is, these turtles started migrating in a large amounts during the breeding season. Now these turtles are endangered species. Now a certain endangered species in an ecological zone due to a construction of industrial park are migrating. Isn't that concerning? So after this report was made public, a collective outrage was there. Now this collective outrage was there among the people residing in Harinagar, specifically one community, that is Kesto community. Why Kesto community? Because this Kesto community is a tribe actually. This tribe was totally dependent on fishing. Now due to the construction of industrial park, their main occupation was taken away from them. Now after this main occupation was taken away, what they will do? They were displaced. Where to go, what to earn, what to eat, that were the questions. Their fundamental rights have been violated, they say. Then they go to the court. How they go to the court? There is an NGO named HOLL, that is Helpers of Living Life. This NGO and the World Wildlife Federation, they together fight for ecological matters and eco-sensitive zone related matters. So they filed a PIL before the Supreme Court stating that this construction activity is illegal, and due to this construction activities, fundamental rights have been violated. And what they are asking is, give us compensation, and second thing they are asking is a certain case order. So there is a similar case that has happened in the Maradu apartments order, wherein in an ecological sensitive zone, Maradu apartments, there is illegal apartment were constructed. Now the court ordered for the demolition of the certain apartments. Now these, in our case, the petitioners are contending that this industrial park is to be demolished and compensation is to be provided. Now with this, the four issues are there in front of the court. First issue being the maintainability. Second issue being the whether the reclassification, we have seen from a strict reclassification to a reclassification where there is a free hand to the government, whether this reassessment and reclassification is valid or not. Third, how did this project got approved if there is already endangered species there in the ecological sensitive zone of Harinagar? If there is olive ridley turtles, how come this project was deemed approved? So this was the third issue. And fourth issue being what liability is lying upon the central government and whether this constructed building should be demolished. So these were the four issues and I was given the respondent side, and with this I will play my recording on my performance. Okay. May I please the court? The counsel is appearing on behalf of respondent in the instant case of Helpers of Living Life versus central government and Reliable Private Limited. The counsel seeks permission to address the bench as your lordships. Much obliged, your lordships. If your lordships are well versed with the facts of the case, shall I state with the jurisdiction of this case?
Yes, please.
Your lordships, the petitioners have approached this Honorable Supreme Court of Sholay under Article 32 of the Constitution, and the respondents submit to that.
Counsel, do you think this petition is maintainable before us?
That is the very first issue, your lordship. That is whether the petition is maintainable before this Honorable Supreme Court under Article 32. Your lordships, the respondents argue that the petition filed by the Helpers of Living Life, that is petitioners, is not maintainable before this Honorable Supreme Court. Mainly, I would break down this issue into two sub-issues. That is, first, whether there is a violation of fundamental rights, and second, what is the role of judiciary while we are implementing the government policies or these government schemes. Your lordship, the first sub-issue, that is whether there is a violation of fundamental rights. So, in Article 21 states that no person shall be deprived of his life and livelihood except according to the procedure established by law. Your lordships, in 1986, the UN General Assembly adopted a declaration on the right of development, your lordships. Now, here we are talking about the displacement of the Kesto community due to the industrial park. Your lordships, this discussion of UNGA, the main heart of the problem agreed by the members of such assembly was that people displaced by this development project are generally seen as a necessary sacrifice, your lordships. Because when we are talking about development, certain things are to be compromised, and in this instant case, your lordships, due to the construction of industrial park, the Kesto community tribes which are dependent on fishing have been displaced. Again, referring to the judgment of Olga Tellis and others versus Bombay Municipal Corporation, your lordships, I have written in the 7th paragraph on page number 8, if I may read, the Constitution does not put an absolute embargo on the deprivation of life or personal liberty. It is far too well settled to admit of any argument that the procedure prescribed by law for the deprivation of right conferred by Article 21 must be fair and reasonable, your lordships. Now, why I am putting forward this case, your lordships, is we have to understand the intent of this very industrial project or the industrial park. Your lordship, the intent of this
Counsel, what are the facts of the Olga Tellis case that you are referring to?
Your lordships, the facts of the Olga Tellis case is the displacement of people which were living on the footpath. So there was a displacement of people who were living there due to a construction of certain industrial project and they were displaced. So this is the case regarding that, because they have argued in court that whether this displacement is justified or not.
Okay.
May I continue, your lordships?
Yes, counsel, tell me one more thing. Do you have any relevant case law along with you? This is a pretty old case law that you have cited. Any relevant case law to show that this particular petition is maintainable before this particular court?
Apologies, your lordships. This is the only one I have currently.
Okay, let's proceed.
Okay. Your lordships, again coming to the very fact that what is the intent of this very project, that is the public welfare, your lordships. Now we are going to, in fourth issue, I will be arguing that how is the Maradu demolition order is this, that case is different from this case, But in this case, your lordship, the industrial park that is being constructed will be given to the companies or rented to the companies which will be producing sustainable energy resources. Your lordships, these energy resources will overall help the village as well as the entire nation for the development. That is public cause. For a public cause, this project is being constructed, which is why it is justified, your lordships. That, and next, the second issue, what is the role of judiciary in interpretation of these government policies? Your lordships, referring to the judgment of Ugar Sugar Works Limited versus Delhi administration, I want to cite that case. It is well settled that courts, in exercise of their powers of judicial review, do not ordinarily interfere with the policy decisions of the executive unless the policy can be faulted on the grounds of malafide, unreasonableness, arbitrariness, or unfairness. Your lordship, these very three words, unreasonableness, arbitrariness, and unfairness. Now, through the construction of our project, that is industrial park, though it will be given to the companies that produce sustainable energy resources. Now, there is no malified intention, there is no unreasonableness in the project,
But
which is the
counsel, tell me, where will any aggrieved person approach if not this particular court? The reason the petitioners have approached this particular court is because their rights have been grossly violated. Their fundamental rights have been violated. So how do we say that this is not even relevant, counsel?
your lordships, it is relevant, your lordships, but the very I'm referring to this case because to show the intent of this project, your lordships. So whether the fundamental rights are being violated, they are not absolute, your lordships. On a certain level, they can be violated only if the project is on reasonable grounds or constructed on reasonable grounds. Then it can be justified, your lordships.
But counsel, don't you agree that their rights have been violated, and that is the reason they are here before the very court?
Your lordships, their rights have been not clearly violated. As again referring to the same case of Olga Tellis, it is flexible, your lordships. If the reason is justified, then we cannot clearly say that they have been violated. Again, in further, I'll be referring to the case of Narmada Bachao. That case also, the though environmental concerns were there, the project was continued. That is the construction of the dam. So their fundamental rights are being violated, but up to a certain level, if the council can justify the intent of this project, whether this project is reasonable for public welfare, then that violation can be justified, your lords.
No worries. Let's go to your second issue. The Governance Act of classifying the area CRC 3B from 1A. Is this valid? So, yeah, tell me, counsel.
Your lordships, it is humbly submitted that this reclassification is valid. Your lordships, mainly in the notification that is given, proper provisions are not given for the reclassification. Further, your lordships, the council believes that under jurisprudence under the doctrine of sustainable development, which is talked upon many times, the sustainable development has come firmly embedded in our constitutional jurisprudence, and sustainable development plays a key important in development. Your lordships, the Supreme Court in Narmada Bachao Andolan versus Union of India upheld the government's decision to proceed with the construction of the Sardar Sarovar Dam despite environmental concerns on the grounds that the decision was
But
based
counsel,
on.
here we are referring to the reclassification. So let's go with the reclassification point itself. So has there been any other project or has there been an instance in the past where a certain project has been reclassified from 1 to 3?
Your lordships, as such, there has not been any proper project which has been reclassified or been justified.
Are you sure?
As of my research, I haven't found any, your lordship.
Okay, let's proceed.
Your lordships, the ground which I am justifying the reclassifications is on the ground of development, your lordships, that whether this project is reclassification is justified because the intent of the project, your lordships, again referring to the same fact that this project will be a huge help and it will help in the public development and public welfare, your lordships, which is the reason why the respondents believe that the project can be justified or the reclassification be justified.
Counsel, but what is the legality on which you are saying that the reclassification is justified? Okay, on moral grounds and on ethical grounds, I understand that this is a project for the government. My question is very simple, that on what grounds are you saying that this is justified, counsel?
If your lordships looking at the moot prepositions, the population factor is given, that is 2161. That can be one ground on which the reclassification can be justified, your lordships.
So you're saying just because there are less population, you can reclassify?
Your lordships, the reassessment have pointed out that the population area there, the density, that is 2161, which is the reason it can be a ground for the justification of this very project.
This 2,000 people, is it per kilometer or how is it?
I believe it's per 1,000 square kilometer. I'm not sure.
Okay, let's proceed. With regards to the third issue, Council, the approval of the SEZ construction to build the project is valid. Council, we think that this project is invalid because, first of all, it's an eco-sensitive zone. And in any eco-sensitive zone, establishing an industrial park is definitely not something that we, as the court, we would like to encourage and register.
Your lordships, regarding the third issue, the WWF report that they have given regarding the impact on the ecosystem that is existed there, that is with regards to olive ridley turtles and their displacement or their nesting zone, which have seen an unusual migration in the while the construction of the project was going on. Your lordship, these olive ridley turtles are defined under Part C of the Wildlife Protection Act, termed as endangered species, your lordships. Furthermore, referring to one judgment that shows the typical pattern or breeding pattern of these olive ridley turtles, that is A. Ayyappan versus the chairman of Tamil Nadu State Coastal Zone Management Authority. Your lordships, why I am referring to this judgment? Because this judgment
What are
show
the
that,
facts of this judgment, Council?
your lordships,
What
it
are the
is
facts of this case?
this very judgment is also justifying one construction project, because one construction project was there in one zone where these turtles were migrating from one place to another. Now, in this case, your lordships, the construction was justified because they showed that the olive ridley turtles, the migration that they are doing in the breeding season, it is justified because they tend to travel thousands of kilometers in the breeding season. It is their natural tendency that they in bulks they transfer from one place, one nesting zone to another nesting zone. And your lordships, in this case, the wildlife report, the report that they have given, they are comparing that due to the construction of our project, these olive ridley turtles are transferring from or migrating from one place to another. Now, this is just a mere coincidence, your lordship, that the construction project and in the breeding season, they are transferring from one place to another. It is not to be justified that because of the construction project, the olive ridley turtles are being transferred, your lordships. Which is the, and also in the same judgment, if I may read, it was held that we are unable to convince ourselves that the construction of the port will result in a serious threat to the survival as a species, though it will may happen the shifting of the turtle from the areas to other more favorable nesting beaches and sites, particularly because the turtle is known for migrating periodically over large distances across the oceans. Now, the very fact that WWF report is blaming or putting certain blame on the company or the industrial park that we are the reason due to which these olive turtles are migrating is not justified, your lordships, which is the reason we can say that the certain project is our project is valid, your lordships.
Coming to the last issue, Council, are you willing to pay compensation?
Your lordships, regarding the compensation part, there are two aspects to this particular issue, your lordships. Firstly being the compensation, and secondly being the demolition order, which they are saying, which the petitioners are saying that this demolition order should be passed, that is Maradu demolition order. Now, if we look at the Maradu demolition order case, that is Kerala State Coastal Zone Management Authority versus State of Kerala Municipality. So that very case, your lordships, the apartments that were constructed were illegally, and there were many errors or factual incorrectness in the very judgment. And second point, that is those were apartments, your lordships, and in our project it is an industrial park, and industrial park, again the same thing, renting the industrial park to the companies which will produce sustainable energy resources. So there is a distinction between these both of the cases. And your lordships, in para number 7, I have mentioned that while we ensure the rehabilitation of the displaced Kesto community, the demand for demolition is legally and factually baseless, your lordships. Why I am saying this? We acknowledge that they have been displaced.
Council, are you willing to pay compensation?
Your lordships, we will indeed pay compensation, but what we are contending is that the project should not be stopped. It should be completed.
What is the amount of compensation that you're willing to pay?
That we have not decided yet, your lordships, but petitioners are contending to demolish the entire project.
That we'll see it later, Council. My question is, what is the quantum of compensation that you're willing to provide?
As such, quantity has not been decided whether rehabilitation
Okay, we
process
will
will be.
propose a quantity, 10 lakh rupees per individual. Is that fine with you?
10 lakh rupees per individual. We will see about that, your lordships. But firstly, we have to stop the demolition order. We have to complete the
We'll
industrial
come to
project.
it later. First, we'll have to see the rights of the people, Council. If you're fine with this, then we can proceed.
Yes, your lordship.
What is your prayer, Council?
Your lordships, wherefore, in the lights of facts stated, issue raised, argument advanced, and authority cited, the respondents humbly pray that the Honorable Court may please and to adjourn that declare the said petition is not maintainable before this Honorable Supreme Court and grant any other relief that the Honorable Court deem fit and proper in the interest of justice. And for this act of kindness, the respondent shall, as in duty bound, ever pay. Much obliged.